Just make sure your cameras are on and your microphones are off so we can avoid any feedback. And I guess I would ask Attorney Del Campo to come on screen, and we can take attendance from members of the committee. Again, if you're not a member of the committee, please turn off your camera for the moment.
Yes, Your Honor. Justice McDonald is here. Judge Chaplin.
Here.
Judge Farley.
Here.
Judge Hernandez.
Here.
Judge McLaughlin, I believe she cannot attend. Judge Nguyen O'Dowd.
Here.
Judge Pearson.
Here.
Judge Prats, I believe she could not attend as well. And Judge Stewart.
Here.
That's it, Your Honor. You have a quorum.
Thank you very much, Joe. I'll call the meeting of the Rules Committee then to order. And the first item on our agenda is the approval of the minutes from the December 12th, 2022 meeting of the Rules Committee. Is there a motion to approve?
So moved.
Thank you, Judge Farley. Is that a second, Judge Pearson?
It is a second. I was muted. My apologies.
Thank you. Are there any changes or additions to the minutes? If not, all in favor, just raise your hand. Opposed? Please say so. That passes unanimously. The next item on the agenda is the proposal, the 2021-027, a proposal to amend the practice book to include uniform standard interrogatories and production requests for real property tax appeals. I believe this had been a item that was a holdover from last year. Maybe Attorney Del Campo can let us know if there's been any developments, or we're just putting this back on to start addressing it again.
Yes, Your Honor. No, this, yes, as you said, this started in March of 2022. It had gone out to the different entities. Judge Cordani commented. The Connecticut Association of Municipal Attorneys commented through Attorney Deneen. It had come back to the committee, and you had asked that it go out again to some attorneys who represent taxpayers, and asked Attorney Deneen for his assistance doing that. It has ultimately gotten out to several different other attorneys. I believe Attorney Servo-Didio and Attorney Coughlin from the Stanford Assistant Corporation Counsel has now seen it, or has been brought in. And I believe that at this point, some of these attorneys are on at the meeting. At this point, I believe the two different groups, or several different groups, would like to meet on an ad hoc committee to discuss this, and to meet out an agreeable or solution to this issue.
Thank you. I did see in the materials that Attorney Servo-Didio, and I see he's on here as well, wanted to comment. Attorney Servo-Didio, could you turn on your camera for 1 second?
Yes.
Full disclosure, Attorney Servo-Didio and I used to be law partners a long time ago. Is there any organized bar for property tax appeal plaintiff attorneys?
No, Justice McDonald.
Okay, because we do have some comments from the Connecticut Association of Municipal Attorneys, and I'd like to have a good cross section of input from attorneys who regularly represent plaintiffs. And if I'm understanding Attorney Del Campo correctly, is there an interest in hopefully you or others meeting with representatives who typically represent municipalities and tax appeals to see if there's some common ground so that we can expedite this or make it a little bit more efficient?
Yes, I've asked two other attorneys who represent plaintiffs in property tax matters, attorneys Amy Bloom and Scott Schweffel, to join me as part of a 6-member ad hoc committee to see if we can discuss and reach a consensus with representatives of the Connecticut Association of Municipal Attorneys on a set of standardized discovery requests for property tax appeals. Just before the new year, the 3 designees from CAMA have been identified. They are, and one or more of them, I believe, are on the call as well. Attorney Owen Weaver, who submitted the original proposal, Attorney Mario Coppola, who represents a number of municipalities as well as some taxpayers, and Attorney Coughlin from Stanford, who was mentioned. So I think, Justice McDonald, at this point, we have an ad hoc committee constituted of 6 attorneys, 3 who predominantly focus on the taxpayer side, 3 on the municipal side, and all 6 of us are willing to sit down and see if we can develop a set of consensus requests. Perhaps somebody on behalf of CAMA can speak, but I believe from prior conversations that CAMA, the board may want some input ultimately, but we do have 3 members from that organization who've been identified now to go forward.
Why don't we do this, unless there's an objection from any members of the committee, of the Rules Committee, I don't see a need to have a long discussion here and now. If, first of all, I should thank all 6 people for being willing to participate in this ad hoc committee. I do appreciate it. And I know some of the people you've identified, and it's a pretty good cross-section of practitioners. I don't, unless people want to ask questions now, I would ask the ad hoc committee to go forth and try to meet together and see how much common ground is out there. And frankly, and I have not cleared this with him, I see Judge Cordani is on the call as well. And I know he's no longer, I don't think he's doing tax appeals anymore, but maybe with his consent, he could be a resource as needed to the ad hoc committee, not to be a member of the committee, but to be a resource to the committee, given his experience. Do you mind me throwing you under the bus like that, Judge Cordani?
Good afternoon, Justice McDonald. No, that will be perfectly fine with me.
Okay, I do appreciate that. So do any members of the committee have an objection in proceeding that way, or would you like to address this matter further at this time? I'm going to take silence as acquiescence. And again, on behalf of the Rules Committee, I want to thank you, Attorney Servideo and Attorney Coppola. And Attorney Coppola, did you want to say anything at this juncture?
No, Your Honor. I think Attorney Servideo has spoken on behalf of the entire committee, and we're all in agreement based on our prior communications. So thank you.
And I do appreciate it. And if you could keep Attorney Del Campo updated on your progress, so that we can keep this on our radar screen. I should note that if anything's going to happen for this court year, I believe our last meeting is in March. So I don't know if there's any urgency to this task, but if there's going to be action taken before we submit our proposals for a public hearing, I believe our March meeting is the last meeting to approve those recommendations. Okay. All right. Thank you very much.
Thank you, Your Honor.
We're going to then move on to the next item, which is 2022-011. It's a proposal to amend the practice book to eliminate the requirement for original printed deposition transcripts and to permit service of civil complaints by consent. I think we're just down to the deposition transcripts on this item. Attorney Del Campo, could you bring us up to speed? I see Attorney Goodbaum is with us as well, but could you bring us up to speed with any new developments?
Yes, Your Honor. This was on the committee's agenda last month. It was tabled to this meeting because you had asked that I prepare an actual proposal. You had discussed the various options in terms of watermarking the document or encrypting it. You had Ms. Mannix from the Connecticut Court Reporters Association do some research in that regard. And Attorney Graziani spoke, Ms. Graziani spoke last meeting from, again, the Connecticut Court Reporters Association on whether or not the document could be in any sense watermarked or encrypted, and you had wished to at least go forward with a draft. There was no draft actually submitted, so you asked me to prepare some draft. I did prepare two options for the committee. They did come in only today, but there are two options in there, basically deleting the requirement that the transcript be sealed and then given to the requester, and then have that attorney file it with the court. That requirement in both options has been deleted. And in the second option, there's a provision in there which requires the reporter to, in some manner, watermark it or put some other indicia on it, which would indicate its origin, for lack of a different term. So you have those two options in your package at this point to at least discuss.
Yes, I do know, I think they just came out to us today. I don't know if members of the committee have had enough time to look at them. I'm seeing some heads nodding no, that they have not had an option to do that. So we're not going to take any action on it today if people haven't had a chance to look at it. But do any members of the committee have any questions for Attorney Del Campo or anybody else on the call before we move on to the next item?
I do, Your Honor. This is Lisa Graziano on behalf of the Connecticut Court Reporters Association. And
Yes.
As a court reporter, I'm going to correct you, Attorney Del Campo. It's Graziano, not Ani. But our only thing would be if you could send us a copy of the proposal that you guys have before you today, so that we could also look at it.
Makes eminent sense. I appreciate that. Attorney Del Campo will do that. I appreciate that.
Thank you.
Anything further? Okay, then we'll pass this item until next month so members can have an opportunity to reflect on it in greater detail. But I do want to thank Attorney Del Campo for drafting those two options for the committee. The next item then is 2022-015. The proposal to amend practice book section 7-19 regarding ex parte subpoenas for pro se or self-represented parties. And I understand that we have some new commentary. We also got I believe everybody has seen that it just came in this morning, a rather lengthy letter from the Connecticut Trial Lawyers Association expressing some concerns with the proposal. I don't know if, certainly at this juncture, we're going to have some kind of dialogue with them to find out if there's anything that can address their concerns. Has everybody gotten the letter that I'm talking about?
Justice McDonald,
Yes,
I'm sorry, sir.
it's
I think
the wrong
the
proposal.
letter has to do with a later item on the agenda. I think it has to do with
Yes.
practice book section 1751, which is
Yeah.
Yes, sir.
Judge Stewart's draft suggested change.
Judge Pearson, you didn't have to prolong my agony. I apologize for the misstatement.
Sorry about
yes.
that. I'm muting him.
Sorry, Attorney Del Campo, please save me from myself.
Yes, Your Honor. Yes, you had passed this last time to public hearing. Actually, you had approved the proposal as drafted, and
This is just the commentary.
yes, you suggested that we have it's a lengthy commentary, so I prepared the commentary for your review. So that's the only thing on the table today, is the
Thank
commentary.
you. I did have a chance to, I apologize again. I did too much going on. I did have a chance to review the commentary. It looked good to me, but I certainly want to open it up to the floor to see if anybody had any concerns about the proposed commentary written by Attorney Del Campo.
I thought it was fine.
So Attorney Del Campo, we don't have to vote again on that, do we? I don't think so.
I would suggest you do, because it is your commentary ultimately.
Is there a motion to approve the commentary as been drafted and circulated to the committee?
So moved.
Is there a second?
Second, Judge Nguyen.
Thank you. Any discussion? All in favor, please raise your hand. Opposed? That passes unanimously. Then the next item is 2022-017. This is the proposal from the FOIC. I understand that the FOIC would like us to table that item at this juncture so that they can continue to see if there are more refined proposals that would address their concerns. Is there any objection to tabling that item at this time? If not, we will move on then to 2022-020, a proposal to amend practice book section 17-51 to explicitly permit the entry of summary judgment based on a defense that when that defense only affects a part of the claim. Please see my comments from earlier. Has everybody had an opportunity to review the letter from the CTLA? I think that was the only submission we got expressing any concerns. Attorney Stewart, Attorney, jeez.
Yes, I did look
Judge
at that.
Stewart, sorry.
That's all right. I think I'm still an attorney too, but I did look at that. I did want to, I mean, it obviously deserves some more thought. I did want to comment on the footnote in the letter because after I did look at stuff, I'm pulling over here. I think it's worth some commentary. But preliminarily, I just wanted to ask, I believe we also sent this to, I saw the CBA response, which was nothing, and I know that it was circulated in the litigation section because I happen to be a member of that and I saw that go around. And they considered it and apparently decided not to take a position. But did it go to the Connecticut Defense Lawyers Association or some entity like that?
Yes, it did, Your Honor. I did receive a response from, I believe it's Attorney Niedermeyer, who was the past president, but he did refer it to the new president. I did not get a formal response from the CDLA at this point. CBA came back with a response, Legal Aid, Judge Bellis, and CTLA.
Okay, so far the only substantive response we've received is the CTLA letter. Anyway, I just want to address, there is a footnote that starts on page 1 of the letter, and it quotes from a footnote in a Supreme Court decision, Liberty Mutual Insurance Company versus Lone Star Industries, which prior to this, I had some passing familiarity with, but I didn't remember this footnote. In any event, I went and looked up the footnote, and it does have more language beyond what's quoted here. And in that case, the Supreme Court, in fact, did permit the entry of summary judgment on part of a count. This was a situation where it's an insurance coverage case. With respect to this one particular carrier, there was a count that alleged coverage under 4 policies. And although the Supreme Court said that with respect to 3 of the policies, summary judgment was improperly granted, they only kicked it back with respect to this particular, a lot of insurance carriers in this case, but they only kicked it back with respect to 3 of the 4 policies. So effectively, they allowed summary judgment to enter. But I'll just note that the language of the footnote after what's quoted in the CTLA letter says, we need not address this division of authority because the parties have not claimed that the reversal requested by American Home presents an impermissible partial summary judgment, and the claims at issue are readily divisible within the single count because they arise from discrete insurance policies. Now, with respect to what's cited in there is this Telesco Supreme Court case. In that case, the trial court entered summary judgment on a count of a complaint that included both a derivative claim and a direct claim against a company. And the Supreme Court correctly observed that the trial court acted as if there was only a derivative claim and completely ignored the possibility that there was a direct claim, and therefore they reversed. So I'm not quite sure how it found its way into this particular footnote, other than it happened to be a situation where there were two claims in account, which is a very common scenario, or was a very common scenario in a lot of the cases that I saw when I first ran into this problem. But I'll just go on and mention the Pelletier versus Sordon Skanska Construction Company case that's cited in here. It's a Superior Court case I referred to in my materials in the first place. That's a situation where the Superior Court did, in fact, allow a plaintiff moving on their complaint to obtain partial summary judgment on part of account based on this same section. And then Fiamengo versus Great American Insurance Company, which is the other case cited, Superior Court case that's cited in here, is a case, and all the authority in it is for the proposition that a defendant can't get summary judgment on a defense for part of account. And that's exactly why I'm moving to change the rule. So I'm not, being an advocate so much as I'm just trying to inform you all as what's really going on in these cases. So I do think that the rest of the substance of the CTLA letter deserves some more thought. I'm just responding to the law that is cited in there. I still think it's an issue, and I do have a concern that we have a procedure that in the front part of the rules, if you will, there's like 6 rules on summary judgment, allows something to happen, but then later on, we're not allowing it to happen. That to me seems inconsistent. And it seems inconsistent to allow a plaintiff to move for summary judgment on part of a claim, but not to allow a defendant. So I do encourage the committee to continue considering my proposal. Oh, and I have one other comment, and that is, as I mentioned the last time, there are a lot of things that this rule isn't particularly well drafted in the first place. I attempted to only deal with my issue, but I think that if there's a little subcommittee that addresses this or whatever, we should look at all of the summary judgment rules because they are kind of inconsistent with one another. One example being, I accepted the friendly amendment the last time that instead of saying final judgment, it should say summary judgment. Some of those other rules say final judgment as well. So that's my piece.
Okay. I'm sorry. Now we're waiting, in addition to the CTLA, we're waiting for any commentary from the new president of the Defense Lawyers Association.
Your Honor, I notice now that Attorney Booker is on the call at the meeting. She is now, I believe, the president of the CDLA to whom the matter was referred. She may be wanting to address the committee. I'm not sure.
Thank you. Attorney Booker, good afternoon. Can you see us?
I can, Your Honor.
Okay, so I don't know how much of this saga you have been following, if you need to have some additional time, but why don't you let us know if you have some preliminary thoughts?
Well, Your Honor, I am new to the situation and would ask for some additional time. We actually have a full board meeting coming up, and I know this is something that our board is interested in. So we would ask for some additional time if that's possible.
I think that's more than reasonable. What I would recommend is, when is your board meeting?
Tomorrow.
Okay, so that's perfect timing. If you have a chance to talk about it with your board, then I'm going to see if Judge Stewart would try to help navigate a discussion with any concerns that your board has identified and the CTLA. And obviously any other member of this committee who wants to participate is encouraged to participate with Judge Stewart. But it's going to be faster and more efficient if we go offline and have some people sit in a room and try to hash out any concerns rather than us doing it in this forum. Do members of the committee agree with that? Okay, Judge Stewart, do you mind taking on that mantle?
No, I do not mind. Is there anyone that wants to join me?
Judge Pearson.
Judge Pearson has gamely volunteered.
Okay. Well, thank you very much, Attorney Booker, and welcome to your new post. We're happy to have you participate in this process on this issue. So if there's nothing further, then we'll pass that item to allow Judge Pearson and Judge Stewart an opportunity to meet with the CTLA and the Defense Lawyers Association on that. And thank them for taking on that additional responsibility. So then I believe our last item then is 2022-021, a proposal to amend practice book section 2-16. This is related to the Pro Hoc Vitae admissions, and the Attorney General's office doesn't want to be the sponsoring counsel. Forgive me, is Jeremy Perlman there? Perfect. Good afternoon.
Good afternoon,
So-
Your Honor.
So let me ask you, and I read your materials, and I understand why the Attorney General's office might not want to be the sponsoring attorney, but it concerns me. Let me say that there would be no local attorney to help guide an out-of-state attorney about the nuances of the practice book, both written and unwritten, right? I mean, there are certain ways things have to happen to get things done in court. And my concern with the proposal is that without somebody being the sponsoring attorney, AGs or otherwise, an out-of-state attorney is going to be ill-equipped to actually navigate the process. And I'm not so concerned about their struggling. I'm concerned more with judges who are going to be faced with attorneys who don't necessarily speak the same language that they speak, if you understand what I'm saying.
I certainly do, Your Honor, and that obviously is a very valid concern. Just by way of background, we work very closely with other state AGs and collaborate with them, and of course would provide guidance, advice, and support for any state AG, out-of-state AG that wants to appear before the court. Our main concern, candidly, is that our enabling statute, or statute that authorizes our office, that provides the authority for the state attorney general, does not provide, does not extend to sponsoring attorneys, and a very conservative interpretation of that statute, could provide a basis for an argument that we don't have that authority to sponsor an out-of-state attorney, Pro Hoc Vitae. So that really is the basis for our concern, is that we may be, challenged by serving as a sponsoring attorney. But certainly there is a valid concern.
I'm sorry, challenged by, is this a theoretical problem, or is this
a theoretical problem? That has not been raised. We're not aware of any opposition, or haven't identified any association or organization that has would potentially oppose this. This is absolutely a hypothetical, but a concern based on the scope of our statute.
Questions for Attorney Perlman? I guess my thinking is it's a hypothetical one. I understand the concern, but with the legislature just starting its new session, typically, I believe the Attorney General's office has several proposals before the Judiciary Committee on any given year. Would it be an opportunity for the Attorney General's office to ask the Judiciary Committee to expand the scope of your enabling statute?
There's no doubt, but that's where the reason that we are here is we see that this would be more in the public interest, because frankly, it's better use of our AAG time and resources representing our state and seeking enforcement of our laws, as opposed to supporting and sponsoring, in court sponsoring other states, seeking, primarily this is really about seeking collection actions against judgment debtors in other states. We had one in September where the New York AG's office requested that we assign an AAG to sponsor 2 New York AAGs for seeking Pro Hoc Vitae admission in a collection action. And as far as we are aware, these are primarily collection actions. So to divert
our limited resources, certainly our attorney's time away from things to help Connecticut and towards this, that is less appealing to us than this option here. And it's also something that we've seen elsewhere. What we've sort of modeled our proposal on is what we've seen. I think it was taken most closely from Delaware Bankruptcy Court, where there was sort of a recognition that other state AGs, or other state attorneys representing other states and other agencies there's a public interest in allowing them to avoid some of the procedural hurdles to accessing the courts.
Okay, Judge Pearson, I believe, had a question.
Yeah, just very quickly, Attorney Perlman, would I be right in saying that, and this is not, I'm not taking a position one way or the other as to whether I think it's a good idea or a bad idea, but would I be wrong in saying that if we adopted this rule, that we would be imposing many fewer applicants on state AGs who apply for pro hoc vice admission than we would be for any other attorney who's out of state applying for PHV admission under 2-16? I mean, am I right? Like, because there's nothing about certifying whether the applicant has grievances pending against them, nothing about the client security fund fees or designating the clerk as an agent. All of that seems to be absent from your proposed language.
Correct, Your Honor. We are our proposal is really sort of limited to allowing access to attorneys, AAGs, Assistant Attorneys General in other states, who are in good standing in all jurisdictions in which they're admitted, agree to be bound by the practice book and the rules of professional conduct, and submit to the jurisdiction of the court for disciplinary purposes. That said, if there are other requirements that would make this more acceptable to the committee, we're all ears. This was our effort to make this work for us.
And I appreciate that. I just wanted to make sure I was reading it correctly. And it may be appropriate that when you're dealing with out-of-state AGs, that we shouldn't be imposing a fee on them or making them do this, that, and the other with respect to their pro hoc vice application. But it is an issue we all will need to think about.
Understood.
Thank you.
Are there questions for Attorney Perlman? Let me ask you, does the Connecticut Attorney General's office ever utilize the services of other states' AGs when they need to appear in other states? I mean, it almost seems like a professional courtesy among the AG's offices of comedy between them to just help each other out in this circumstance.
It absolutely is. Our first attempt is to find somebody within our office that's admitted in the other state. Absent that, we ask the other state for assistance, and we go through the same procedural challenge that other states do when they don't have a provision like this.
Okay, so given the fact that this is, I understand it's a theoretical problem, it's not a pressing problem, I would propose that we just table this for now, and I would encourage the Attorney General's office to approach the legislature about whether this would be appropriate for the AG's office under the statute. I would rather, I think it would help the court if there's an attorney from the Attorney General's office. I guess you could require somebody to hire a state to hire an attorney in the Connecticut to be the sponsoring attorney. I feel like this is a little bit more of a policy issue for the legislature than us. Maybe we have concurrent jurisdiction. I don't know, but could you find out from whoever is responsible in the AG's office for the legislative package about whether they think that's something that could be offered to the legislature this term?
Certainly, Your Honor. And let me just finally make one other point, and that is the obligation to serve as a sponsoring attorney in Connecticut under the rule is more than just sort of serving as a mailbox or showing up. They need to be engaged. And that is also, again, to your point, it's hypothetical, it's theoretical, but it is possible that our interests may not be entirely aligned with the state of the other state and put us in a position where
I understand that position. There's nothing, unless I'm having another senior moment today, there's nothing here that obligates the Attorney General's office to do it, right?
No, correct.
So if something was anathema to the interests of the state of Connecticut, I guess the Attorney General's office could decline.
Absolutely. I mean, in the course of the case, there could be, a separation or difference in views on how to proceed, but certainly that's not the primary concern here. Just, we've sort of looked at this and considered a parade of horribles that are possible, but it's all theoretical. Our primary concern is that we could get down the road of some significant litigation, only later on to be challenged that we had no authority to be to be in a sponsoring role, and that our statute is limited to only the statutory authority we have.
So, absent any other input from members of the committee, I would ask you to keep in touch with Attorney Del Campo and keep him abreast of the AG's efforts to try to address and expand the scope of the enabling statute in the legislature. Okay?
Very good, Your Honor. Thank you.
All right, thank you. I should have said, is there any objection from members of the committee to proceeding in that manner? Okay, thank you. Then I think that's all we had on our agenda for today, unless anybody has anything else they'd like us to raise at this juncture. If not, I will accept a motion to adjourn. Otherwise, we're going to stay here.
Motion to adjourn.
Moved by Judge Pearson. Is there a second?
Second.
Seconded by Judge Stewart. All in favor, please raise your hand. Opposed? That passes unanimously. Thank you, everybody. I appreciate your time and efforts.
Thank you.
Thank you.